Imagine telling a British politician in 2005 that within a few years the High Court would be under a new court, the Supreme Court, a court separate from Parliament, a court with its own building, a court that would hear the most important constitutional cases in the country, a court whose decisions would dominate headlines during Brexit, devolution disputes and clashes between government and Parliament. Many would have said, why? Really? After all, Britain had functioned perfectly well for centuries without a Supreme Court. The highest court in the land already existed. The law lords sat in Parliament. The legal system worked. So why create a Supreme Court at all? Did we actually need one? Or was the creation of the UK Supreme Court an unnecessary constitutional reform that made judges more political and politics more judicial? Well, politics have certainly become more judicial under Starmer. But is that just a tactic as politicians use acceptable phrases to get what they want? They all do it. To understand the debate, we need to understand what changed. Before 2009, Britain's highest court wasn't the Supreme Court. Final appeals were heard by the Appellate Committee of the House of Lords. The judges involved were law lords. Technically, they were members of Parliament. In practice, they operated independently when acting as judges. And this arrangement had evolved over centuries. It was unusual, but it worked. And then came the Constitutional Reform Act of 2005. With some fanfare and very little public debate, the Act created the UK Supreme Court, which formally opened in 2009. The stated purpose was straightforward: to strengthen the separation between Parliament and the judiciary. Supporters argued that in a modern democracy the highest court should be visibly independent. But visibly independent? The average person probably didn't know that the law lords sat in the House of Lords and were members of Parliament. Independent, and I think it's fair to say there hadn't been many questions of their political independence. We had a separation of the powers, even if it wasn't specifically codified in a constitution. So in fairness, it gives institutional clarity. Modern democracies generally separate legislative, executive and judicial powers. But I would argue they were separated. Yes, it could be taken as blurred constitutional boundaries, but anyone who understands anything about the British Constitution understands that it's all about blurred boundaries. You weren't allowed to have a Catholic Prime Minister until one was elected, and then that constitutional convention evaporated. And frankly, with so little fanfare that 99% of people probably can't name who that Prime Minister was. And it was in your lifetime. Maybe a dedicated Supreme Court is easier for citizens to understand, provides a visible focal point for constitutional questions. But it also creates this weird window dressing where it covers a constitutional change just because that's what people think a constitutional government looks like, without any view as to whether it worked in the first place. I've always favoured gradual evolution over radical redesign, and that places the burden of proof on the reformers, and the fact that it happened so quietly suggests in itself that there wasn't much evidence of need for reform. What it has done is judicialise society. Questions once resolved politically are increasingly ending up in court. Britain traditionally relied on parliamentary sovereignty. Parliament is sovereign. It makes decisions, it's responsible for those decisions, and no one has power above Parliament except for the theoretical power of the monarch. Parliament made laws, courts interpreted them. The boundaries were clear. Over recent decades, constitutional litigation has increased. Brexit provided the most obvious example. Cases like Miller 1 and Miller 2 place the Supreme Court at the centre of major political controversies. Supporters view these judgments as essential defences of constitutional principles, but critics viewed them as evidence of judges becoming involved in political disputes. And it did feel like they were being political at times. As once disputes reach the courts, judges inevitably become participants in those constitutional debates. Whether that represents healthy oversight or judicial overreach depends on your view. And there's an important misconception that the Supreme Court is like the American Supreme Court, because that's the one that we all understand, right? That's the one that people actually talk about. Probably before the Brexit or even before the transgender judgment, it's probably fair to say that the majority of British people didn't know they had a Supreme Court, and when they found out they had one, thought that it was like the American one they've seen on TV. But it's not like that at all. It can't strike down Acts of Parliament. And under parliamentary sovereignty, Parliament remains legally supreme. The court can only interpret legislation. It can review executive actions, it can determine whether governments acted lawfully, but it can't simply invalidate primary legislation. However, when it makes judges make judgments that a government acted unlawfully when there isn't a law that says they can't do something, is that not them going beyond interpretation of legislation? Takes me back to Lord Hailsham in the 90s with his interpretive approach to legislation. The Supreme Court has raised the role of lawyers in decision making over the validity of laws, and this increases legal dispute, creates a more legalistic approach to government, and offers an avenue for overthrowing the legitimate government's decisions. Now, abolishing the Supreme Court seems unlikely, but government should draft legislation more clearly to reduce excessive reliance on judicial interpretation, and constitutional questions should be resolved politically where possible rather than through litigation. And really, a public understanding of the court's actual powers should improve. Finally, judicial appointments should continue emphasising legal expertise and institutional independence rather than political considerations. And judges need to seem a lot less political, and I'm afraid that's probably not a question of the Supreme Court, that's a question of the bodies that govern the courts and sentencing.